What is involved in bringing a medical malpractice action? First, it's important for a patient to understand the medical treatment involved. So they need to explain to us the facts with regard to the medical care that's been rendered to them, or their understanding of what's been told to them about the medical care in question, so that we can appropriately analyze that information and then seek necessary medical records to go ahead and screen the case for viability. In a medical negligence case, one of the key things that we need to prove in order to be successful for our clients is what's called a deviation from the accepted standard of medical care. So there are certain standards of care that physicians and hospitals or facilities have to follow with regard to the treatment that they render to patients. And if they don't fall within that standard of care or provide care that's in line with that standard of care, it can be considered medical negligence. And negligence is not only acts of medical treatment that may be inappropriate based on a particular patient, but also omissions on the part of a doctor or facility with regard to the medical care that's being rendered. In order to initiate a lawsuit, first you would want to talk to experienced attorneys who handle these types of claims to see if a viable case exists, whether or not there is a deviation from an accepted standard of medical care, and whether that deviation was a substantial factor in causing a specific harm to you as the patient or to a loved one if you are calling on behalf of a loved one. So the plaintiff in a medical malpractice action can be the patient themselves. Okay. Obviously someone who's been injured as a result of a deviation from that standard of care that we talked about. But also a plaintiff may also be someone who's been legally appointed to speak for a patient who cannot speak for themselves, or in the event that a patient has passed away, possibly as a result of medical negligence. The appropriate person who would bring forth the cause of action at that stage would be the executor or executrix of their estate, if they have an estate, or an administrator or administratrix of an estate, if one should need to be appointed in light of the patient not having a will in place. So you would contact a law firm, talk with them about the case, and perhaps request certain relevant medical records to go ahead and take a look at. And then once it's determined that you do have a viable cause of action against particular medical defendants, you would file a lawsuit in the county in which the medical treatment was rendered. And that lawsuit would be initiated by the filing of a complaint, as well as what are called certificates of merit. Certificates of merit are essentially declarations that say that an expert in the same field of medicine has reviewed the case and noted that to a reasonable degree of certainty there was a deviation from that standard of care and that this case is justified, essentially giving you the green light to go ahead and move forward with the claim against the physicians or facilities involved. Needless to say, this is a complicated process, and it requires attorneys to not only understand the legal rules in terms of filing these types of complaints with the court, but also have an understanding of the medical treatment that's involved and to really have a grasp of the medical concepts and the standards of care that are applicable. So we do encourage you to contact our law firm, Comets Law Firm, as soon as possible to discuss your potential case. We can be reached at 570-829-1111.